There are questions asked to you on drafting. You are supposed to draft some pleadings, applications, SLPs in your exam. So I told him that I will tell the young lawyers what judges expect from them. And in the process, maybe few little secrets I'll be divulging to you. Because I remember long back, I was in Aurangabad bench of Bombay High Court. I had a long sitting. Then I was invited to address young lawyers who had recently joined practice, those who are practicing up to 5 years. And there was an interactive session. So one, I was taking an assignment of second appeals under section 100. So one lawyer asked me, young lawyer, sir, how you are able to read 60 matters, 70 matters every day? Second appeal is always difficult in High Court. I said, I will not divulge many secrets. So I told young lawyer, you know, you may be a legal wizard, but if you want to read judgments of both the courts, trial court and district court, you won't be able to read more than 30, 35 matters. But I divulge the secret. If I have read 40 matters on a particular day, if 41st matter is called out, first question which I would naturally put to the lawyer is, yes, mister, what is the substantial question of law? The lawyer is under impression that I have read that. Therefore, lawyer would say, sir, only 2 submissions, then I'll sit down. So I get a signal that there is nothing in the second appeal. And with our experience, sometimes, you know, we can read from the body language of the lawyer also, whether he has any merit in the case. So, in the process of having dialogue with you, I may share some secrets also. See, ultimately, why you draft a case? It may be SLP, it may be writ petition under Article 32, it may be a suit on the original side, it may be a delay condonation application. See, ultimate object is not only to file it because client comes to you and he pays you the fees. The ultimate object is that if possible, if your client has a good case, the client must get some relief from the court. So nobody should be filing it for the sake of filing. It should not be the approach that, look, client has come to me, he has given me few documents, only impugned judgment is there, there are no other documents. So you are not expected to file a half-baked petition, half-baked SLP. See, ultimately, what judges expect, you know, nowadays there are on Friday, Monday and Friday, there are 60, 65, 70 matters. So we as judges, when we sit with those files, either on Thursday or Saturday or Sunday, all that we expect is that SLP is drafted in such a manner that within no time we are able to understand what is the real controversy. That's our expectation. Ultimately, if you file a proper SLP containing proper annexures, that puts the judges at ease, because we know everything. Now, day in and day out, I see this. Now, for example, SLP is filed which arises out of a criminal appeal. And every Thursday and Sunday, we read the matter. And sometimes the entire issue revolves around deposition of 1 or 2 eyewitnesses. If we go through the judgment of the appellate court, that is the High Court, all that we need to see is deposition of 2 witnesses. But if those 2 depositions are not on record, then you are putting the judge under more stress. Then we go to the trial court, we try to find out what is the finding of the trial court. So therefore, it is not enough that you have copies of the impugned orders and you file a petition. Other day I dealt with SLP. There are 2 bulky judgments, 50 pages by trial court, 35 pages by district court, and around 40 pages by High Court. Now, what was the issue involved? Whether the document, which is subject matter of the suit, was a conditional sale or mortgage. You know, now law is so settled, right? From Chunchun Jha and other cases is settled. But if we don't have that document annexed to the SLP, how we are going to decide? We will read judgments of the 3 courts by spending time, or at least 2 courts, or at least High Court for that matter. But if you don't annex that document, how are we going to decide the matter? Case after case, I see this, that material documents are not annexed. In many cases which arise out of writ jurisdiction, There are government orders in some states, they are called as, some states they are government resolutions, whatever name. They are government orders, executive orders. The entire case is based on interpretation of government orders. But those copies are not annexed. So ultimately, if you want relief from the judge, you must make the judge comfortable. And therefore, there has to be a proper drafting. All documents must form part of your SLP or your, for that matter, writ petition under Article 32. One more area where I think lot of improvement is needed, where you must apply your mind. You know what, if you have to read 35, 40 matters, then you can be very meticulous. You can go through each and every page. But if you are required to read 70 matters every weekend, then if your synopsis is defective, the very purpose of having synopsis is defeated. So before you file SLP, you must be fully conversant with the facts of the case. Only if you have fully studied the matter, then you will be able to draft proper synopsis. I can tell you from my own experience as a judge, I'll be completing 20 years of judgeship, 2 High Courts and now Supreme Court. As judges, we feel happy, if we feel relaxed, if there is a proper synopsis and proper list of dates, which gives all material particulars. Not only the statement of dates and events, but against every date, if you mention in the bracket where you will get that particular document. Now, in most of the cases, the way SLP is filed, we don't look at the synopsis because we find that after case, the synopsis is very defective. Now, please place yourself in position of a judge. If you have a very meticulously drafted synopsis, the judge will be able to understand more quickly what is the controversy. See, ultimately, you must think on these lines, that today client has come to me, he has paid me money, he wants me to file SLP, or he wants to file SLP with application for condonation of delay. Your first object should be that you will file the case in such a manner which will make out some point in favor of your client and which judge will be able to appreciate. Now you can do that provided your petition is complete, all relevant documents have been annexed. On this aspect, I want to make suggestion to even the association. Now, serious issue which we see in Supreme Court or maybe in High Courts also now is issue of translation. The translations are incorrect. Sometimes they can be misleading. But now I want to share something with you. I mean, the lawyers have capacity to do what I am going to suggest. I have been made chairman of the committee which monitors translation of judgments of the Supreme Court into regional languages, or translation of judgments of the High Court in their own local languages. Last 3 months I have been working on that. Then I have suddenly realized that there are so many good softwares available, either paid or free. There's a Bhashini software developed by NIC. There's one software which is paid software, Case Mine, Google, Microsoft, everybody has these softwares. And if you start using those softwares, of course, you can't simply rely upon that translation. But what you have to do is what we are doing when we are translating the judgments of the Supreme Court into regional languages by using that software. That job of translation, whatever AI tool, whatever software you use, it takes 4 to 5 minutes to translate, 4 to 5 minutes to translate about 300 pages, even less than that. Then all that you are required to do is, you are required to only manually compare whether translation is correct. And those who are working in the field, they tell me that more and more work you do on a particular software, automatically the legal glossary is uploaded into software. In fact, it's quite easy. I mean, you can consult some expert that if you want to translate something from Hindi into English, now there are softwares where if you can upload the legal glossary into Hindi glossary, which can be translated into English, it becomes very easy. So I think Bar Association must take help of experts now and start using AI tools or software for translation. So coming back to the point, if you are translating a particular document, if you are filing translation, for example, in SLP, there is dispute about interpretation of the will. and where the court is required to read the will, if the translation is not proper, then the whole purpose of filing SLP is frustrated. Because we as a judges, we immediately notice that there is something seriously wrong with the translation. I may not be conversant with many languages. I can read Hindi, I can read Marathi, to some extent I can read Gujarati. But if it is in other languages, we need translation. So as advocate on record, it is essential part of the drafting that you must file properly translated documents.